Thank you for joining me today for the 11th annual David H. Bodiker Lecture on Criminal Justice, which is being featured as part of our Discussions from Drinkle Hall virtual education series. As the Dean of the College of Law, it's such a pleasure to have you here with us. And I want to take just a moment to remind you of the purpose of the Bodiker Lecture, as well as introducing our terrific speaker today. As was detailed by his wife and daughter during last year's lecture, David Bodiker steadfastly maintained his advocacy for the rights of death row inmates, and the legacy of passion that he exuded in work and in life continues to inspire us all. I'm so pleased today that so many of you are joining us for this virtual lecture, including members of David's family, friends, and colleagues. The purpose of the David H. Bodiker Lecture is to promote, improve, and advance the highest level of academic and professional interest in protecting the constitutional rights of the defendant in the criminal justice system. This year, we are so proud to continue this important tradition while honoring David's memory with our distinguished guest speaker, Deborah Archer, Professor of Clinical Law at New York University. Professor Archer will present on Jim Crow in the 21st century, policing-based housing policies, racial segregation, and mass criminalization. Her lecture seeks to investigate and unearth the realities of policing-based housing policies as a signal of sustained racial segregation. Professor Archer holds a BA in government from Smith College and a JD from Yale Law School. She is also the president of the American Civil Liberties Union and a nationally recognized expert in civil rights, civil liberties, and racial justice. Professor Archer previously taught at New York Law School and worked as an attorney with the American Civil Liberties Union and the NAACP Legal Defense and Educational Fund, where she litigated in the areas of voting rights, employment discrimination, and school desegregation. Her impressive focus shining a light on the inherent inequities in our society, which persist to this day, embodies the essence of what David H. Bodiker Lecture is all about. Please join me in welcoming Professor Deborah Archer.
Thank you, Dean Davies, for that introduction. And thank you for inviting me to participate in this lecture series in honor of David Bodiker. The importance of this lecture series really can't be overstated. We as a society are facing so many challenges and questions when it comes to criminal justice. And I'm really excited as a person who's not traditionally seen as a criminal justice scholar to be here to talk about one way that the criminal legal system is expanding to further impact the racial justice challenges we face and fight every day. So broadly, my work focuses on how racism persists in its power. I try to identify and also challenge with my students and my own advocacy the architecture of racial inequality, really exploring the laws, policies, cultural norms, and structures through which racism continues to constrain the life outcomes of some and expand the life outcomes of others. And recently, my research has had a more specific focus on understanding the modern drivers of racial segregation and concentrated poverty, including the criminal legal system. As you know, America remains profoundly segregated along racial lines. We live separately, we learn separately, and we socialize separately. And the systems this country has so effectively built to protect and maintain segregated communities have a tremendous negative impact on those who are left out. And this is not because Black people and other people of color would get some magical benefit from living closer to white people or sitting in a classroom with white people. It's because we cannot separate the places that people have access to from the opportunities that people have access to. Our homes, not only the physical residence, but also the community in which it's located, impacts our lives in numerous and interdependent ways. There's really nothing that place does not touch. Our access to education and jobs, our physical safety and our health, our access to healthy food, our social networks, the number and nature of our interactions with the police, even the quality of the air we breathe are all deeply impacted by where we live. And in so many ways, the history of Black people in America is a history not only of control, but of exclusion, and legal and social limitations on how and where Black people live are central to that history. And these exclusions have proven to be extraordinarily durable, outliving both chattel slavery and Jim Crow. The United States has a deep-rooted history of exiling marginalized people from communities of privilege. And indeed, this is part of a tradition of exile that America has embraced for centuries. We can start with Native Americans who have long endured attempts at exile, banishment, and extermination. There were government-supported campaigns to exile formerly enslaved people to parts of Africa, first to remove a threat to the institution of slavery, and later as a proposed solution to racial violence following emancipation. During World War II, Japanese Americans were forced into internment camps to isolate the threat that they allegedly posed to the country. And the embrace of exile was also evident in Jim Crow policies around the country, where white people created white-only spaces like schools, neighborhoods, parks, and restaurants by excluding Black people through violence, through law, through custom. And America's embrace of exile to protect white spaces included countless acts of racial violence throughout the 19th and earliest 20th centuries. White people, driven by white supremacy and hatred for Black people, used violence, intimidation, and the law to rid their communities of Black people, to separate Black people from opportunity, and to keep Black people in what they believed was their place, physically, socially, and economically. But among the most effective and durable tools of exclusion are the police and our criminal legal system. From their inception, police have been tasked with protecting power and privilege by exerting control over Black people and enforcing racial order. Modern policing has its roots in the suppression of slave revolts and in the creation of patrols to capture enslaved people who had escaped. Police were not the only tool of control of formerly enslaved people. Every element of the criminal legal system was brought to bear. And even as chattel slavery ended, Black people were pulled back into forced labor through convict leasing systems. Communities created categories of crime as a pretext to arrest Black people, or they just arrested them without the pretext of having committed a crime at all. And courts sentenced them back into forced labor. During Jim Crow, police brutally enforced segregation, and police officers often joined, supported, and protected the lynch mobs. During the Civil Rights Movement, police beat protesters who marched for equality on national television. And when Black people dared to move into historically white neighborhoods, police were enlisted to ward off residential integration and protect the people who terrorized Black families. Underlying all of this is the narrative linking race and crime, which has endured for centuries as a justification for segregation and subjugation. This began during slavery, when a common narrative was that Black people were savages, prone to violence and criminality unless they were domesticated and made docile. Slavery was, they said, to Black people's benefits. And this narrative of excessive Black criminality has evolved, but it has remained central, a central thread in the conversation about racism throughout the United States. During Reconstruction and throughout Jim Crow, as Black codes in the South and discriminatory policing in the North criminalized Blackness, sociology and statistics replaced Darwinism and eugenics as alleged proof of innate Black criminality. And in the progressive era, well-meaning reformers advocated for more humane treatment of people convicted of crimes, but they still warned that the Black criminal was a breed apart because we innately had a propensity for crime. And now in conversations ranging from criminal legal system reform to family law to education to housing, these racialized narratives fuel a general state of anxiety and fear and brand Black people as dangerous and inhuman. As Ibram Kendi recently wrote, to be Black in racist America is to be armed and dangerous even when we are unarmed and walking away. That mark of criminality exists for Black people and other people of color, even in the absence of actual criminality. Today, this country continues to use exile and exclusion as a means to define the boundaries of citizenship and belonging. And given our long history of using the narrative myth of Black criminality as a justification for segregation and subjugation, it should be no surprise to any of us that central among the modern tools of exclusion are laws ostensibly motivated by the desire to keep certain communities safe that use contact with the criminal legal system as a measure of dangerousness and use the police as the enforcement tool. And these newest tools in this arsenal of exclusionary tools are what I refer to broadly as policing-based housing policies, which really do bring together all of these threads. These housing policies take various forms, but all encourage or require property owners to keep out people with criminal legal system contacts. I think the name policing-based housing policies is apt because these policies not only use the police for enforcement, but they're also grounded in popular theories of policing, such as broken windows and hotspots policing. And they also adopt many of the enforcement goals, strategies, values, and narratives of the criminal legal system. The adoption of policing-based housing policies has really become entangled with societal assumptions about the criminality of Black people and the criminal legal system's march towards mass criminalization. And despite a growing consensus about the harms caused by mass incarceration and many high-profile efforts to reverse our race-driven over-reliance on imprisonment, mass criminalization has nonetheless seeped into virtually every aspect of society. And against this backdrop, the adoption of policing-based housing policies act as a system of essentially racialized agreements between community members to exclude people of color and define the boundaries of who is allowed to live and thrive within their borders, and thus who can be shaped living in these communities. By combining the brutal efficiency of mass criminalization and the racism of the criminal legal system, policing-based housing policies risk profound damage to the physical, economic, and psychological well-being of its victims, mostly Black and brown people. Today, I want to focus in on one category of policing-based housing policies, crime-free housing ordinances. And crime-free housing ordinances are local laws or policies that either encourage or require private landlords to evict tenants who have had varying levels of contact with the criminal legal system, or to decline to rent those tenants in the first place. These ordinances have the purported goal of stemming crime in rental housing, but they are much more effective at excluding racial minorities and promoting racial segregation than they are at stemming crime. Crime-free housing ordinances, unsurprisingly, have their roots in the law enforcement community. The first ordinances were created by the International Crime-Free Association, which is an organization that was founded in 1992 by a member of the Mesa Police Department in Mesa, Arizona. And the ICFA has successfully, since then, spread the adoption of crime-free housing ordinances across the United States. And today, according to one study, over 2,500 municipalities across 44 states have adopted crime-free housing ordinances or programs. In California, for example, about 1/3 of all local governments have a crime-free ordinance or program. And additional towns and cities have adopted nominally voluntary programs that are administered through the local police department. In their most problematic form, crime-free housing ordinances make even alleged criminal activity a violation of the rental agreement. They allow police officers to decide whether a potential tenant's criminal history disqualifies them from rental housing in the community, or whether a tenant must be evicted because of alleged criminal activity without any meaningful due process. And they also allow revocation of a private landlord's authorization to rent their property for failing to act on those police determinations. And very significantly, a resident does not have to be convicted in order to be evicted. A common crime-free lease addendum provision, which is the model that's pushed by the ICFA, explicitly states that proof of a violation of this lease provision shall not require a criminal conviction. And this creates the possibility that a mere arrest or even a stop that results in neither arrest nor conviction might be sufficient to evict someone from their home. And I want to share two examples of programs, one that is mandatory and one that's nominally voluntary. The example of a mandatory program is from Faribault, Minnesota. First, the ordinance creates a requirement that all owners of rental housing obtain a license from the city to operate a rental dwelling, and lays out a series of requirements for obtaining and retaining the license. One of those requirements is that every landlord has to conduct a criminal background check, and to prove to the police department in Faribault that they have conducted that criminal background check, and then to keep the results of that background check on file for 1 year after they have either decided to rent to or not rent to any tenant. And interestingly, the police officer who runs the training program in Faribault was quoted as saying, "Just come on down to the police department. You may not find any criminal convictions, but that doesn't mean that there's not a wealth of information that we can provide on these prospective tenants," encouraging landlords to look beyond traditional measures of criminal activity to come and speak with police officers. Another requirement is that they have to include a crime-free provision that's mandatory in every lease. And the mandatory crime-free lease provision prohibits a resident or guest from engaging in, quote, illegal activity on or near the premises. And notably, the ordinance does not define what constitutes illegal activity, making any alleged violation of the law grounds for eviction after a single violation. And finally, the ordinance gives the Faribault police the power to order eviction of a tenant pursuant to the lease addendum without an arrest or conviction. If the police department determines that a tenant or occupant is in violation of the provision, the landlord must terminate the tenancy of everyone in the unit and may not enter into a new lease with any of them for 1 year. Orlando, Florida is an example of a voluntary program, and it has several components that I think are worth highlighting. The centerpiece of the program allows a property to advertise that it is crime-free if the property management agrees to include, again, a specific crime-free lease addendum in all of its leases. The language in the Orlando lease addendum provides that once a property owner or manager is notified that a tenant has been arrested, they can fill out an eviction form and give the accused resident just 7 days to move out. And again, a resident does not have to be convicted in order to be evicted. And properties that participate in the crime-free program also receive a weekly tenant eviction list, which identifies all renters who have been evicted pursuant to the crime-free program. And the purpose of this list, according to the city of Orlando, is to ensure that someone evicted under this program will not be able to move to new housing anywhere in the community. Although Orlando's program is nominally voluntary, in a single 5-year period, approximately 1,400 people were evicted under the program. And the overwhelming majority of those evicted were Black or Latinx. One of those people was Leroy Banks. When he was 21 years old, police suspected that Mr. Banks broke into a car. The police questioned him and he denied that he had any involvement. But in connection with his questioning, the police checked Mr. Banks' criminal history, which showed that he had 2 prior arrests, but no convictions. The officers turned that information over to the rental complex where he lived, and the building management immediately started eviction proceedings against him. It also should be no surprise that crime-free ordinances disproportionately exclude people of color and further racial segregation. Involvement with the criminal legal system effectively functions as a racialized criterion for who can live in a community. And this is because there are extreme racial disparities in who has contact with the criminal legal system. And the impact here is heightened because of the breadth of crime-free ordinances. These exclusions are not only based on convictions, but by design and implementation on any contact with the criminal legal system, from convictions to arrest, to stops, to suspicions. And they impact not only just one building, but an entire community. They force people to be evicted, but also prevent people from being able to live in that community in the first place. And the discretion these laws give to police officers and landlords is also ripe for abuse. It's easy to see how bias by law enforcement and the disproportionate enforcement of criminal laws leads to a regime where people are excluded from housing and community for reasons having nothing to do with safety and everything to do with racism. In Hesperia, California, a city with a particularly onerous mandatory ordinance, the United States Department of Justice determined just last year that Black residents were almost 4 times more likely than white residents to be evicted under the city's crime-free housing policy. And Latinx renters were 3 times more likely than white tenants to face eviction. They also determined that nearly all evictions under the policy occurred in non-white neighborhoods within the city. And it's just not the potential for abuse that's problematic. There is evidence surrounding the adoption of some of these ordinances that racial segregation may be more than an unfortunate byproduct. Crime-free housing ordinances are often adopted following burgeoning racial diversity and not burgeoning crime. For example, of the 20 California cities with the largest increase in Black population since 1990, 80% have a crime-free ordinance or policy. Of the 20 California cities with the largest increase in Latinx population since 1990, 75% have a crime-free ordinance or policy. Again, I think Faribault, Minnesota is an instructive example. The Black population of Faribault, which is composed almost entirely of Somali immigrants and refugees, nearly tripled between 2000 and 2010. And the 2010 census showed an increase of 214% in Faribault's Black population since 2000, and a 263% increase in the Black population living in the downtown area of Faribault during the same period. And although residents of Faribault began complaining about increases in crime during this period, the overall crime rates in Faribault did not, in fact, increase dramatically. So the motivation behind these laws are also permeated with racial bias. Moreover, I think crime-free housing ordinances can lead to exclusions or evictions because of police contact resulting from the weaponization of police by community members suspicious or resentful of people of color solely because of their race. The phrase living while Black has been used to encompass the innumerable ways Black people are viewed with suspicion and required to justify their presence in spaces where they are seen as not being in the norm. Sociologist Elijah Anderson explained that there are white spaces where Black people are not often present or exist in limited numbers. And when in white spaces, Black people are often required to provide justification and proof to police or to other citizens that they belong. And when those suspicious of Black people in white spaces call the police to enforce those exclusions, these criminal legal system contacts can then pose numerous risks to the health and safety of those being policed, but they can also result in criminal records justifying housing exclusion. The combination of expanding police-based housing policies like crime-free housing ordinances and the spike in police officers responding to complaints about people of color living their lives in white spaces increase the likelihood that Black people and other people of color will experience exclusion from traditionally white residential spaces. And again, together they risk working in the same way as racially restrictive covenants, which are community-based contractual agreements prohibiting the rental to certain groups of people, here people of color. Crime-free housing ordinances also ensnare people who have not engaged in activities that meet any reasonable notion of crime. The entanglement of policing-based housing policies and mass criminalization is really pushing already marginalized people further to the edges of society. And the more we criminalize relatively innocuous behavior, the worse the problem gets. In the end, these policies exclude people who pose little or no threat to the community. Families who have been banned because their children engaged in behavior that would be of little consequence in other communities. people fighting substance abuse disorders, people targeted by the over-policing of Black people in Black communities, and victims of the weaponization of the police. An example is Thelma Jones, a Black woman who lives in Faribault, Minnesota. And after living in Faribault for almost a decade and in her then apartment for 5 years, Ms. Jones was informed by her landlord that she and her children had 2 weeks to move out. The landlord told Ms. Jones that the police advised the landlord to evict her because the police had responded to complaints at her home 82 times. And they characterized Ms. Jones' home as a location of ongoing criminal activity. In fact, Ms. Jones and her children did not have any criminal convictions. However, the police had come to Ms. Jones' home repeatedly because of harassing calls to the police by her white neighbors. On one occasion, police responded to calls because Ms. Jones was hosting a family barbecue. On another occasion, police were called when Ms. Jones hosted a child's birthday party. Police even responded to calls each and every time her children were outside playing on their trampoline. Ms. Jones and her family were evicted not because they were engaged in criminal activity on or off her property, but because she was a Black woman who was unwelcome by her predominantly white neighbors. Mass criminalization feeds this myth of criminality and validates unwanted fear, and in turn, crime-free housing ordinances weaponize that fear. And crime-free housing ordinances are providing an already racist criminal legal system with a broader province of impact and influence. Race plays an undeniable role in policing in the United States. And by utilizing the principles of policing in both design and implementation, crime-free housing ordinances import racially discriminatory policing practices into the private housing market and weave housing policy and the criminal legal system together, both ideologically and functionally. Ideologically, the normative values of the criminal legal system are infiltrating housing determinations. Specifically, housing policy is adopting the policing-based values of exclusion and punishment and treating applicants and tenants as suspects and blurring the line between housing determinations and policing. Functionally, crime-free housing policies give police officers outsized power to determine who can and cannot live in certain communities. These policies essentially allow police officers to pick and choose who may live in their community simply by making the practically unreviewable assertion that an applicant or a tenant engaged in illegal activity. Ultimately, the denial of housing is being used to punish criminalized people, both those with meaningful criminal legal system contacts and increasingly those without. And the consequences for those exiled are really devastating. And given the close connections between law enforcement, the criminal legal system, and race, for many people of color, exile is almost fate. And today we're having a really long overdue conversation about the need to reimagine policing, public safety and community safety. But this conversation has to be about more than a reexamination of traditional policing. We also have to examine the expanding role and power of the police and stop providing our criminal legal system with an ever-growing and increasing province of impact and influence. And crime-free housing ordinances and policing-based housing policies more broadly are definitely a move in the wrong direction. So thank you for listening, for this opportunity to share these concerns, and I look forward to your questions and comments.
Thank you so much, Professor Archer, and I only wish we were all here in person so you could hear what I'm certain would be thunderous applause. But let me take a few moments. We have some questions that have come in, and just as a reminder to everyone in the audience, if you'd like to ask a question of Professor Archer, we do have a bit of time to be able to do that, so please use the Q&A function in your dialog box to be able to put forward questions. So let me just start with a couple of questions I'm going to pair together from the audience, Professor Archer, and I think these highlight in part the sort of need and how illuminating I think your remarks are in showing us ways in which racism in our country is not just what some people think of as sort of intentional acts, but systemic and built into the fabric of our society. So one question relates to how widespread these crime-free ordinances are, and if you have a sense of that from a kind of statistical or quantitative basis. And a related question is whether any of these ordinances have been challenged in courts, and if so, what kind of consensus, if any, is there?
Yeah. So I appreciate you starting off by talking about the need to understand the true nature of racism. I think that too often people believe that racism is about individuals who have hate of another group and then act on that hate, but really we tend to ignore the way that racism and inequality are built into our systems and structures, the way those systems and structures come together and feed the kind of inequality that we're seeing today. In terms of how widespread they are, there's been one comprehensive study from some years ago that says there were more than 2,500. And I think that that's a low estimate because communities continue since that study to adopt mandatory programs by their city councils or to allow their police departments to have what they're calling voluntary programs. I've seen them in every kind of community across the country, from big cities to smaller towns. I've seen them in predominantly white communities mostly, but we also have seen them in more diverse communities. So for example, Savannah, Georgia adopted a crime-free housing ordinance. They have abandoned that ordinance after the ACLU pushed back and made them aware of the dangers and impact that kind of ordinance was having on the community. So I do think that they are much more common than we know and much more common than any of us should feel comfortable with. In terms of challenging ordinances, yes, there have been a few, not enough challenges around the country. I mentioned Hesperia, California, and the United States Department of Justice last year filed a challenge against the ordinance in Hesperia, focusing on discriminatory enforcement of that ordinance. A group of civil rights organizations, including the ACLU, filed a challenge against the ordinance in Faribault, Minnesota. They had a more expansive view. They included claims under the Fair Housing Act of intentional discrimination. There was lots of evidence that racism motivated the adoption. They also included two different types of claims that focused on the disparate results that the ordinance had. One was a disparate impact claim, arguing that it excluded disproportionately Black and Latinx folks from the community, but they also included something that's called a segregative effects claim, which is an underutilized tool within the Fair Housing Act that focuses on the impact of policies and laws on further entrenching racial inequality and segregation within a community. I know that there are also challenges bubbling up a lot in Illinois, where there have just an incredibly high concentration of crime-free housing ordinances. And there have also been claims using the Constitution, both federal and state constitutions. So there are some challenges. They're not across the country. And unfortunately, I think this kind of case-by-case litigation may not be effective in countering the incredible expansion we're seeing of crime-free housing ordinances. There has to be more community-based knowledge and awareness of these ordinances, the impact of these ordinances, and then community pushback against these ordinances.
Terrific. And I do want to circle back to some of the questions that we have about solutions here and what efforts might be made to address that. But before we go there, let me ask a question from one of our students that actually also occurred to me while you were speaking. So I think maybe two minds are great. So how is it that these are being sort of perpetuated across the country? Are there certain drivers for the adoption of these ordinances? Is it property owners? Is it city officials? Is it police? Is there some kind of information cascade that's occurring amongst associations of rental property owners? I guess where are these coming from and how are they spreading?
Mm-hmm. So I think it's an example first of the power of just one organization, the International Crime-Free Association. If you visit their website, they have all the tools that make it very easy for a community to adopt a crime-free housing ordinance. They have the sample lease provision. They have the language that you can use to describe the program. They have sample ordinances that the city councils can just pick up and adopt wholesale. And we've seen that. The reason that so many of these mandatory lease provisions are similar is because they're all modeled after the International Crime-Free Association. We're seeing that a lot of these ordinances around the country are similar because they are all been adopted and use the language of the International Crime-Free Association. The International Crime-Free Association provides training modules that you can use in your community. So they make it very easy for a community to adopt the model that they've created. In addition, I think it's communication and coordination between police departments, speaking with each other and saying this is the best way to move forward. I think it is also about the narrative, a narrative that's being perpetuated around the country that in order to be safe, it means that certain people can't be a part of our community. It's a narrative that says there are no second chances, that we can't take the risk of giving anyone a second chance. And again, it's a narrative about Black criminality that has just been perpetuated over centuries, that's continuing to drive these conversations and these decisions.
So let me ask you a question that's come in through the chat on that front. The question is this: based on stereotypes we see on TV and in films describing or depicting housing projects as either gang-based or used by gangs for illegal activity, is there any reality to this, and is there any support for any kind of crime-free rules amongst the minority?
Yeah, I think that those are complicated images that we're seeing. There is a sense and a narrative that predominantly communities of color, predominantly Black communities, anywhere that there are a majority of Black people living, is somehow plagued with criminality. And that's a false narrative that we need to start to push back against. The way that the media will highlight incidents of crime within Black communities or in public housing developments and make that seem like that is the norm, and that epitomizes every resident of a public housing development or a resident of a Black community, is also a narrative that we need to push back against. The idea that someone who was arrested for shoplifting when they were 17, or someone who was caught in the parking lot of a building smoking marijuana, creates some kind of danger to everyone who lives in that community, is something else that we need to push back against. Certainly, we all want to live in communities that are safe, but crime-free housing ordinances is a false tool. It's not a tool that's going to make our communities safe. It is a tool that is going to exclude a certain category of people because of racism, and in the end could make our communities less safe because we are telling those people, you can't live here, and with the increasing expansion of crime-free housing ordinances, you can't live anywhere. At a certain point, where are folks who have had contact with the criminal legal system supposed to go? And again, it's people who have had no meaningful contact with the criminal legal system are also excluded. I don't think anyone would say that Ms. Jones from Faribault, Minnesota, presented a danger to her community, but these crime-free housing ordinances characterized her and her family in that way and made it difficult for her to find a place to live. I think there are examples of better ways to go. If we look to, there's been a movement in political participation in employment that recognizes that this perpetual exclusion of people who have had contact with the criminal legal system doesn't serve us well. It doesn't serve the individuals, but it doesn't serve us well as a community. And so if we look in New York, where they've had ban the box in the employment context, you can't automatically exclude someone because they've had contact with the criminal legal system. You should think about the length of time that has passed since that contact, the nature of that contact with the criminal legal system, what has happened in that person's life in the intervening years. Was their contact with the criminal legal system driven by a substance abuse problem, and have they had treatment and family and community support and engagement since then? There's so many factors that determine whether or not someone can be deemed to pose any kind of concern to residents of a community. And crime-free housing ordinances don't allow that kind of analysis. Policing-based housing policies don't allow that kind of analysis. And instead, they literally, and this is drawn from some of the training modules, say that people with criminal legal system contacts are a cancer. They're like weeds that need to be rooted out and removed. And that's just not an accurate narrative. That's not a narrative any of us should be comfortable with. And it's not a narrative that's true to who we say we are, that we are a community that provides second chances. We are the land of second chances. We need to flip this around and try to invest in folks who have had criminal legal system contacts, to invest in their success and their future and their stability and their reentry and reintegration into our communities.
So you mentioned the Ban the Box program, and there's actually a question coming in about that. So I'm going to turn there in just a moment. But I also want to say the questions are flowing in. We're going to get to as many of them as we possibly can. But the other thing about that is I think it's just reflective of how important the forums that we provide through universities like Ohio State and through law schools like our own are so critical to our democracy, to be able to have these meaningful dialogues on challenges of our day and really the most pressing questions of our day. So I, again, want to thank you, Professor Archer, for sparking such a wonderful conversation. The ability to address these questions from diverse and different perspectives, I think, is really meaningful. So let me turn to that Ban the Box question, which is pointing out that some studies have shown a kind of perverse impact from the Ban the Box program, which, as you noted, forecloses employers' ability to ask about criminal history on job applications. Those effects, this question is indicating, have shown that sometimes what that means is that then employers use race as a proxy, relying on implicit bias, and then that has the perverse impact of excluding those who might be qualified for positions. And so the question is whether limits on these kinds of programs, crime-free ordinances, might have the same effect.
Yeah, I think that those things are happening, whether or not we have ban the box programs and whether or not we eliminate crime-free housing ordinances. We know that, as I said during the talk, that there's this link between race and crime in this country that has been persistent and stubborn and hard to shake. And whether or not there exists any actual criminality, the idea of criminality, the notion of criminality stays with people of color, particularly Black people. And there was a study, a really important and fundamental study, that said that a white person with a criminal conviction is actually seen as more trustworthy and more likely to be hired than a Black person without one. Because I think in many ways that mark of criminality follows us whether or not we have a conviction. So I think I don't think that that's justification to keep these discriminatory policies in place. I think to me that means that we need to work harder, more focused, more aggressively to challenge the implicit and explicit biases that would lead someone to then say, if I can't check for sure whether or not you have a criminal conviction, I'm just going to exclude all Black people. I'm just going to exclude all Latinx people. That we have to challenge that more directly. And that's a complicated process. It certainly involves narrative work, challenging those narratives that persist and the discrimination that underlie those narratives. It is work for us to try to unlink our criminal legal system and race, to really address the systemic racism that has woven itself into our criminal legal system over centuries. It's a challenge of the media. We heard from an earlier questioner about the images that we see that kind of perpetuate this belief that Black people are criminal. I think it all shows the impact of Ban the Box, the negative side effects of that show to me that we've got to come at this from all sides. It's not just one policy solution that's going to fix everything. We have to continue to fight on all sides using every tool that we have available.
Great, you've mentioned solutions. I do want to turn to that in just a moment. We have several questions that have come in about potential solutions. But before we go there, let me ask just a pair of questions further about sort of impact of these programs and what that looks like. There's one that's come in about whether there's kind of any overlap in the impacts of these programs with those who've previously been homeless and what that might look like. And then another question relatedly asking about cross-sectionality in terms of folks that might be have disabilities or people who are disabled that live with low-income family members and what that might mean in terms of sort of extra impacts or disservice to society.
That's a great question, or a series of questions if you mush them together. I think really important topics to address. On the issue of homelessness, absolutely. In communities around the country, we're seeing that homeless folks are being blocked from housing because of crime-free housing programs, but also broader policing-based housing programs, becoming ineligible for public housing and not able to access private housing because of the way that we criminalize homelessness. People are arrested for various things because they have no place else to go. They have no place to sleep, and they're arrested for loitering or trespass. And that those arrests create the kind of criminal legal contacts that are going to lead to exclusion from housing options. And I'm not remembering the person's name now, but I recall a story of a man who was living in Illinois and homeless and was on a waiting list for public housing for 5 years. And during that time when he was on the waiting list and was homeless, was arrested a series of times for various things, all resulting from the fact that he needed to find a place to sleep at night. And when he finally got to the top of the waiting list, they said that he was ineligible because of those convictions and was not able to access public housing. So absolutely, there's an interaction with homelessness. There's also been more discussion around disabilities and the gender aspects of crime-free housing ordinances and nuisance laws, which are the sibling of crime-free housing ordinances, and relatively little attention paid to the racial justice aspects. So with the nuisance ordinances, which are often adopted at the same time as crime-free housing ordinances, the police can deem, or the city can deem your house to be a nuisance and tell you that you have to evict the tenant who is creating that nuisance. And nuisance includes the number of calls to the police department and the number of times the police have had to come to your home. And so the disability community has pushed back against those ordinances in many places because of the way that it can make people less safe if they need to call the police or other services for assistance. Folks in the domestic violence advocacy community have also pushed back against nuisance ordinances because they limit the ability of people who are experiencing domestic partner violence to call for the police. They have been reluctant to call for the police because if we call the police too frequently, they'll deem our home to be a nuisance and will evict us. And that has happened in instances around the country. So certainly there are many manifestations of the harm that we see coming from crime-free housing ordinances and nuisance ordinances. But I think the aspect that has been least discussed and explored is the racial justice impact and the impact that it has on perpetuating and locking in segregation and racial exclusion.
All right, so let's take a moment and turn to some of the questions of potential solutions in this area and what might be done. And I see one coming in from one of our alums who I know has done some of his own work to fight racism in housing ordinances in places such as California. So here's the question. What's the most effective course of conduct to combat these types of ordinances? Is it local communities? Is it publication of them? Is it voting? Is it campaigns? Is there something else?
Yeah. So I personally believe in the transformational potential of integrated advocacy, and that is using every tool at the disposal of lawyers. So litigation, legislative advocacy, community engagement, public education, everything coming together at once to achieve social change. And I think that crime-free lease programs and crime-free housing ordinances, that's an area that needs pushback on every level. There are certainly communities around the country where there's potential by just engaging with city council. And we saw that in Savannah and in other communities around the country. By community pushback, we're seeing more and more education, public education be effective as landlords and potential tenants understand the way that these ordinances are functioning. More and more are pushing back. But there are communities where I think that kind of community-based advocacy won't be effective because the discrimination is so entrenched, the police department is so powerful, or the city council fully embraces that ordinance, that litigation is critical. And I think I've seen the most success using the Fair Housing Act as a tool. And certainly the Fair Housing Act has so many provisions and manifestations that we can use. But litigation is expensive. It is time consuming. And so I'm in favor of trying to couple litigation with all the other tools that we have to try to empower communities, inform communities, and have communities use their power to push back against those who represent them to make changes at the local level. And I would say that litigation is hard because these are not statewide laws or a federal law. It is literally town by town, city by city. And that's a difficult way to move forward if that's our only strategy.
Right. So on that front, there is a question that's come in about a particular city's potential solution to this, mentioned in Seattle, and a first-in-time ordinance in Seattle that requires landlords to rent the unit to the first qualified renter, in turn trying to prevent them from claiming there were other more qualified renters. And so the question is whether a solution like this might be able to be propagated across towns and cities, and whether you think that would be a particularly effective solution.
I think that's an interesting solution. But I think my mind is resting on the word qualified, requiring landlords to rent to the first qualified applicant. And so there'll be a fight over qualified, and the ways that criminal legal system contacts come into play when we define who is and who is not qualified. It certainly helps to take away relative qualifications, so you don't have to go to the person who's making the most money, who has the longest history. But again, would qualified also exclude people who have been evicted and their eviction records, which may have been influenced by previous ordinances and other discrimination? Would that make them not qualified? But I certainly think that that's an interesting idea, something I would want to think about. Would that have residual impact, other impacts, collateral impacts on who has resources and access and ability to be first in time? Is something else I would like to see and explore. And I wonder if this person knows, if they want to email me, if there have been some studies or initial look at the data from this Seattle ordinance. But it's an interesting question, but I think a complicated one too.
Okay, so I want to, just watching the clock, and we only have time for a couple more questions, want to pull the lens back just a little bit and ask an incredibly thoughtful question that's come in from one of our attendees, and it's this. We're living in a time of great contestation against the neoliberal state where housing precarity and mass criminalization are central. The questioner is asking whether you might be able to talk about the relationship between organizing against police violence and organizing for housing justice. Mm-hmm. Cases where organizers or communities themselves are linking their struggles for housing justice and against police violence.
Yeah, and I think that that's a wonderful question. I think we absolutely should link those things. As I said, when we're in the conversation around policing, too often we are focused on traditional policing, so looking at and examining the role of police as we have traditionally defined it. But I think we should be taking a step back and looking at violence that's perpetuated against communities through police and through the criminal legal system, and violence more broadly. And there certainly is violence in our housing system. There's violence in eviction. Eviction is a violent act. There is violence committed against communities through our family law courts and systems. So I do think that there is importance and there is power in linking all of our struggles together. That when we tend to silo our work, we don't give effect to the true power of communities coming together. We don't fight in a way that I think is going to effectively push for and build community power. And we don't fight for justice in a way that's going to result in community justice and broad community justice. So absolutely linking all of those fights together, recognizing and challenging the violence that weaves through all of these systems, I think is important moving forward. It has always been important. Some of our best successes in terms of advancing conversations around justice and fighting for long overdue reform or transformational change have come through linking struggles together and building power in that way.
All right, so let me ask just two last questions. This one comes in from the audience as well, and touches on a theme we started with, the idea that racism in our country is systemic and not just individual. And the question notes that there's often a shared historical context for people in our country, and that it's hard for anybody to take the time to sit down with every single friend or coworker and try to provide sort of historical lecture or exploration of racism in America. So they're wondering whether you have any recommended works, articles, books, etc., documentaries that people might use to better understand these issues.
I think that that's a challenging question. When we talk about systemic racism, it's important to understand that systemic racism as it impacts Black people is different than systemic racism and the way that it impacts members of the Asian community or Latinx folks. And so one book to help us understand racism as it applies to various communities, I think is a challenge. I think it's maybe more helpful to think about the role of white supremacy more broadly and to learn about the role of white supremacy. I think the increase in racism and violent hate crimes against Asian people that we have been witnessing is really a display of racism, misogyny, and cruelty, but it's also a reminder that it has never been about Black versus white. It has never been about white versus Latinx. It's always been about white supremacy and people with power creating whiteness as a means to justify and codify their supremacy over others. Black people and Indigenous people were the original victims of whiteness in the United States in this way, but of course not the only. And whiteness has been used to oppress Asian people, Latinx people of every nationality. And so in the end, it's a paradigm of power and oppression. And I think finding ways to study that is important. But I think also finding ways and reading about how to connect the dots. So books like The Warmth of Other Suns, helping us understand how we got from point A to point Z is important, and trying to find ways for you to dig into that and those concepts, I think, would be helpful.
All right, wonderful. So we often talk about students first at our college. So I'm going to end with a question from a student as well.
Okay.
And this is, I think, hopefully sounding a note of hope. The question is, what career advice would you give to law students who want to work to dismantle systemic racism. How does a student begin going about this daunting task?
Like that could have been the whole lecture series.
Yeah, I know.
So I think personally that more and more as a law professor, I am trying to find ways to channel my inner Charles Hamilton Houston. And Charles Hamilton Houston was a former dean of Howard Law School, director of litigation for the NAACP, and he was an architect of the litigation campaign to end racially segregated schools that resulted in Brown. And he not only taught his law students to conceive that separate can never be equal, he taught them how to develop a legal theory in support of that idea, and then to develop an integrated advocacy strategy that integrated the litigation strategy with other advocacy efforts to give that theory legal effect. And more of us need to teach in that model, and I think law students should seek out opportunities to learn in that model, to understand the complex interplay of systems that are woven together. In conversations with law students far too often, I think that they believe that there is one lever that they can pull to solve society's problems. I had that conversation many times when it comes to policing, that they believe that there is a one point solution and we just need to figure out what that solution is. But really, it's about understanding the many, many systems that have led to that moment of police violence. And that includes unemployment and segregation and homelessness and substance abuse disorder, just so much that comes into play. So taking advantage of opportunities to learn those systems. And at the end of the day, I think the most important thing that you can do is to join the fight for social justice. Professor John Powell has said that we can all be a part of the circle of human concern, and that extends to how we engage in the fight for social justice. So I think young lawyers and law students should understand their own theory of change. They should understand their strengths, their passions, and pursue social justice in that way. We should not limit ourselves to just one or two tools in a lawyer's toolkit. We need to come at this problem from all sides. I personally try to engage in as many of using as many tools as I can. And I have changed my focus throughout my career. And I just think law students should not feel limited at all, that they should view expansively. And then finally, I would encourage law students to try to come out of the silos that many of us find ourselves in, to engage with the broader context, to try to think in terms of power and systems. Kind of thinking and focusing on individual problems is going to bring some resolution to our client's immediate situation, but it doesn't always lead to the deep long-term change, to the shifts in power, to community equity and justice. And so to find opportunities to learn about and engage in thinking about how we change systems and how we shift power to those who are most impacted.
Wonderful. And on that note, I want to say that, we're often reminded that the motto of Ohio State is Disciplina Veritatem, which means in Latin, of course, education for citizenship. And so I want to thank you today, Professor Archer, for delivering a lecture that is not only worthy of the Bodiker lecture name, but I think is emblematic and indicative of that motto, education for citizenship. Thank you for sharing your insights with us for what has been just an incredible lecture, and I think really illuminating on many issues in society.
Thank you for having me.
I wish that what I could do is to give you this award in person, but we will get it to you in New York City. And thank you again for joining us. And as folks depart, let me just take a moment to note that we have another Discussions from Drinker Hall next week. We're going to celebrate Earth Day. It focuses on the role and the rule of law in building a more sustainable and just future. I'd encourage you to join us next Thursday. There's also CLE credit that is going to be available for that. And so with that, I will say once again, many thanks to Professor Archer, and go Bucks.